Good morning, dear Professor Matsushita. On behalf of the Rector of Saratov State Law Academy, and for me personally, I'm glad to greet you at the second festival of Saratov Legal Science. 2017 is the year of ecology in Russia, and we're discussing about a lot of global ecological problems. And of course, we're happy to see a foreign professional today. And we will be very grateful for your lecture focused on the legal regulation of natural resources management in Brazil. Thank you very much.
Thank you, Kirill, for this kind invitation to be part of the second International Festival of Science at the Saratov State Law University. I also would like to thank the Rector of Saratov State Law Academy, Dr. Sergei Surovov, and also to you as the president of the Soviet Postgraduate Student Association. My topic today is to tell about the legal regulation of natural resource management in Brazil. As you know, here in Brazil, oh, sorry, not in Brazil, but in Brazil, we do have a lot of income relations about natural resources. And it's also the oil a great issue for us, as you have your own natural resource in Russia. Arising for the structural change in the information and communication technologies and for the globalization movement that reach economy and the law. The standpoint of today's law, it's bound to the universality and non-transferability parameters for the human rights, which despite being treated as vague and be excessively unspecified and merely programmatic, are now being used in new connotations which are increasingly specific as democracy and legal hermeneutic progress, promoting the empowerment of freedom, equality, and fraternity aspects, so that they can effectively be a part of regulation parameters in benefit of human beings, not only individually, but only egalitarian, but including and especially in a common and global way. One of the most important documents acknowledged worldwide is the Common Rights Area in Brundtland Report, made by UN World Commission on Environment and Development in 1987, resulting from a conference of specialists in Indonesia, Brazil, and then called Union of Soviet Socialist Republics, among others, which defines a critical perspective on the development model adopted especially by the developed countries, while highlighting the risks of non-considering the finite capacity of the ecosystems. The mentioned report is one of the references in the international politics attempt to bring forth the constant need of adopting global parameters of sustainability against the consumption and production patterns currently effective. On June 1992 in Rio de Janeiro, in Brazil, a heads of state conference organized by United Nations entitled United Nations Conference on Environment and Development, also known as ECO 1992, was held, and the document known as Agenda 21 was prepared during it, which is a program that seeks feasibility of new sustainable development pattern associated with social justice and economic efficiency, and with representatives from Brazil, the host country, Russia, and other 177 other nations. The United Nations Framework Convention of Climate Change established, based on ECO 92 and Agenda 21, was ratified by and by most countries, including United States. For example, the Kyoto Protocol did not have the same treatment. The ratifying of this protocol by Russian Federation signed in 1999 and ratified in 2004 was of a major importance, for it fulfilled one of the components to be considered in effect, which was the adhesion of industrialized countries that together contribute at least 55% of the global gas emissions for the countries comprised in an attached one of said protocol. The United States have refused to ratify said that document. It had 189 ratifications in total. Brazil ratified it in 2002. The Kyoto Protocol is an international treaty with more strict compromise concerning reduction of emission of gases that cause and escalates the greenhouse effect, especially the CO2. It is noticed that Brazil has been incorporated into an international system for environmental protection and therefore a rational and sustainable administration for natural resources. Thus, it is worth mentioning Principle 13 of Declaration of Rio de Janeiro of 1992. Each government shall develop a national legislation regarding the liability and indemnification of victims of pollution and other environmental damages. Each government shall also take part in prompt and more determined way in the development of international rights regarding the liability and the indemnification of negative effects of the environmental damage caused in areas outside its own jurisdiction by activities in its own jurisdiction or under its control. Therefore, it's relevant countrywide that the country has conditions to set a reasonable and strict program seeking for a satisfying environmental governance in a global scale. Additionally, establishing communication channels between public, private, and the third sector institutions is essential to strengthen the Brazilian and global institutions concerning the environment. About the public administration of natural resources in Brazil. The environment administration is planning, direction, control, resource allocation, among others, carried out in order to obtain positive effects on the environment, reducing or eliminating the damage or problems caused by human action or avoiding their occurrence. The rise of natural resource administration as a research field is one of the essential components of the regulation process for the mutual relations of the social-cultural system in the biophysical environment. It is made in a way to comprise a consequence of interactive activities between the economic practices and the press for environmental protection. The National Environmental Policy in Brazil, enacted in Act number 6938 of 1981, which created the environmental national system in Brazil, the CINAMA, and was duly accepted by the Federal Constitution of 1988. It's one of the great Brazilian natural resource administration regulation plans. For example, in Article 13, The law requires that the executive power shall encourage the environmental activities in order to develop research and technological processes in the country, which should be destined to reduce the deterioration of the environmental quality, to the production of the anti-pollution equipment, and to other initiatives that promote the streamlining of nature resource usage. In Article 9, it also established some of the national environmental policy instruments. The establishment of environmental quality standards, the environmental zoning, the environmental impacts assessment, and the licensing and revising of activities that cause or may cause pollution. Furthermore, according to the Article 2, the law requires that the goal of the national environmental policy is the protection, improvement, and recovery of environmental quality sustainable for life, in order to ensure country conditions for the socioeconomic development, national safety interests, and protection of human dignity on a national level. In order to achieve that, the principle of governmental action in maintenance of ecological balance, among others, is enforceable in a view of the environmental as a public heritage, which shall be duly secured and protected for the sake of public usage. It also sets forth as an environmental resource at the atmosphere, inner, surface, and underground waters, estuaries and territorial waters, the ground, the underground, the biosphere components, the fauna and the flora. This is the Article 3, number 5. This regulation supports the enforceability of constitutional provisions. Thus, according to the Brazilian Constitution of 1988, among its main regulations concerning the natural resource protection, established that the adequate legislation regarding forests, hunting, fishing, fauna, nature preservation, ground and nature resource defense, environmental protection, and pollution control are under the responsibility of the federal and state governments, along with the federal district. This is the Article 24, number 6 of our Constitution of 1988. It also dictates that if rural property complies with an adequate usage of natural resources, which are available to the environmental protection, its social rule and fulfilled by the Article 186, number 2 of our Constitution. Meanwhile, the Article 107 rule the Brazilian economic order, sets forth that the economy order based on a human labor appreciation and free entrepreneurship. These both values, who look like not to be working together, seeks to ensure a worthy life to every individual according to social justice rules, in consideration of certain principles, such as environmental protection, including with a special treatment as the environmental impact of products and service and their manufacturing and supply processes may be. In Article 225, under Chapter 6, entitled Environment, the Brazilian Constitution established that every individual is entitled to an ecologically balanced environment, which can be used by every person, and it is essential to a healthy life quality, being the duty of the public authority, and the collectiveness to protect and preserve it for the current and next generations. In this regard, there's a cooperation exercise in Brazil among the federal, state, and city governments related to environmental law. Rejecting the centering culture and resulting in some sort of ecological cooperative federalism, which explicitly incorporates the principle of cooperation for the Brazilian legal system. This vertical formula of environmental legislative power distribution supports a cooperative system, and therefore not focused on the exercise of such constitutional legislative power, which forms the regulatory basis for the democratic, inclusive constitutionalism. The public environmental administration is the public authority action conducted according to the public environmental policy. The public environmental policy can be understood as a set of goals, guidelines, and action instruments that the public authority has available to produce desirable effects of the environment. The first instrument is associated to environmental administration environmental administration is the environmental impact assessment. We call here as a EIA. It goes to ensure the compliance of the nature environmental policy proposes through the preventive assessment of projects that are likely to cause environmental damage, while reviewing the likely impacts on the environment in order to act in an adequate way during the approval process. According to the Principle 17 of Rio Declaration on Environmental and Development, environmental impact assessment is a national instrument, shall be performed for the planned activities that may have a substantial negative effect on the environment and that are subject to a decision for the relevant national authority. And EIA, this environmental impact assessment, is prepared under environmental researches, which are made by interdisciplinary teams that present diagnoses and assessments regarding the potential environmental impacts and effects for the specified project. The Environmental Impact Report, the EIR, reflects all the conclusions presented in the ERA, and it's associated to a review and public participation process. Unfortunately, as you know, here in Brazil, we are in a way to reveal a lot of problems about corruption. And for sure, there are a lot of problems here in this kind of regulation about environmental issues. And the most important is before all the constructions or problems we had before 1981 and before 1988, our constitution, they can be removed. For example, there are a lot of houses constructed in areas protected, ambiental areas protected, which cannot be going in the ground because they did this before this regulation. So we do have a lot of rich houses constructed close to the beach in a very beautiful places in the forest. They cannot be restricted because of this regulation we are living here in Brazil. But the regulatory Brazilian body is the Environmental National Board. We call it here the Environmental National Board as CONAMA. It was created by the Act number 1938 of 1981 for the purposes of advising, studying, and proposing to the government board, which advised the President of the Republic in the preparation of the national environmental policy guidelines for governmental policies associated to the environment and natural resources, besides delivering on regulations and standards that are adequate to an ecologically balanced environment, which is fundamental to a healthy life policy. This is the Article 6, number 1 and 2 of that law. The rule of enforcing and applying to the policy and governmental guidelines on a federal level belongs to IBAMA, the Brazilian Institute of Environment and Renewable Natural Resources. As mentioned before, the power to legislate on the environment is divided by the federal, state, and city governments, as well by the federal district. Consequently, there are also bodies related to the subject matter in each Brazilian state, such as INEA, this is the State Institute of Environment in Rio de Janeiro, the FATMA, Foundation of Environment in Santa Catarina State, and CETESB, Environment Sanitation Technology Company in São Paulo. The environmental impact report reflects all the conclusions presented in the EIA, and it is associated to a review and public participation process. For example, it's a common example, for sure, it's a common example, easy example for me. In 2014, we had a very strong problem about drinking water in São Paulo state, especially in the city of São Paulo. We're a big city, as you know, and we had only around 5% of the resource in drinking water for the city. It's only 5%. It's not enough to 30 days of water in São Paulo. So our lakes are very, very down, and we do have a very strong problem in this issue. I live in a building in São Paulo, and the condominium, they want to do a hole to seek water underground. So we apply for the CETESB, which is the company here in São Paulo. We take care of natural resources, and it takes 2 years to approve to the approval for us, so we can grab a hole and take the water underground. So now we do have our own water for the whole building for around 200 people who live there. So, but this is the kind of issue we do have in Brazil. It's a very soft regulation about everything, and also besides, we do have a strong, not soft regulation, a strong regulation. The ways to take care of our environment, it's not good enough, and it's also not strong enough to take care of the corruption problem we do have here in Brazil, unfortunately. But in theory, it's important to you to know also that here in Brazil, there are also so-called command and control instruments, or directive relation instruments, which aim to reach actions that deteriorate the environment by limiting and conditioning the use of goods, the performance of activities, and the exercise of individual freedoms in benefit of the society as a whole. The economic instruments which are related to a granting of benefits or the enforcement of penalties and difficulties. depending on how the performance activity and, and the good or deterioration brought to the environment are related. Also other incentives which progress directed to society's direct intervention and education. Therefore, the instrument of public environmental policy may be characterized in three different ways. One, common and control instrument associated to the emission quality, performance, and technological standards, prohibition and restrictions in the production, trading, and usage of products, among others. Two, economic instruments related to the tax and pollution and on the use of natural resources, tax incentives to reduce the emissions and the protected resources, compensation for conserving environmental services, negotiable penalty permits, funding under special conditions, and etc. And three, miscellaneous, which are means to support the scientific and technological development through environmental education, the unit protection and public information. Furthermore, which such instruments the government has duty regarding the environment and natural resources of treat the market flaws, which account for substantial disparities and environmental deterioration, considering that the economic theory intrinsically tends to ignore non-monetary costs and consider certain natural elements such as free and clear property, such that each producer passes on part of his costs to the society. Furthermore, those public instruments of administration of the natural resource mean nothing without the direct and continuous contribution of the civil society. Thus, despite the legitimate possibility of sanction enforcement and private behavior regulation, we are aware that an organized civil society must be present and act upon any decision centers related to environmental administration. In this regard, there are two concepts of governance coexist. The first one is directly mainly to reinforce the economic liberalism by the removal of the government. And the second one determines the counterproductive operation of the institutional systems derived from the modern era, in order to view evolution forms for said systems, in a sense of establishing current territorial policies. I do not believe that environmental governance theory necessarily implies the removal of the public authority, but it shall cause the adoption of shared administration with the civil society regarding the environmental liability. Consequently, the private natural resource administration structure it's also characterized by the institutional rules and resolutions that tend to provide harmonic relationships between the companies and the environment. It is worth mentioning to the various standards NBR ISO 14,000, which ensures the safeguard of the environment by private economic agents. These rules, the ones under number 14.1 and 14,001, 14,004, refer the environmental administration systems, a process that assimilates different business area and keeps track of their operational flaws, providing standards, routine, and procedures facilitating their administration and subsiding the decision making. An organization that intends to remain competitive should apply to its strategy to certify to sorry, an organization that intends to remain competitive should apply to its strategy the certification through the ISO 14000 standards, because the ISO 14400 uh, standard is the environmental rules goes beyond national boundaries and puts environmental administration the same level achieved by quality administration. Hence, yet another constraint is created for the success of companies that export and dispute their share in a globalized market. Reconciling the environmental features of the products and services with worldwide conservation model is an increasingly essential requirement for the organizations to be more competitive and keep their hard-earned commercial positions. Consequently, a company acting in a sustainable manner has to contribute to solve social and environmental problems besides generating long-term value to shareholders and or owners. The Natural Resource Private Administration in Brazil, it's a sustainable business. Are they the ones that fulfill their current need by using resources in a sustainable manner? Maintain balance regarding the natural environment based on clean technologies, resource reutilization, recycling, or renewal. Restore any damage caused by themselves, contribute to the solving of social problems instead of horse-winning them, generate enough income to the maintain itself. In that sense, besides the pressure of government and civil society, including customers, toward companies to start acting in a sustainable way, there are also a few voluntary non-governmental organizations initiatives that invest in their partnership with certain companies in order to strengthen environmental protection programs. The UNEP-FI is an example, which is a global partnership between United Nations Environmental Program and the financial sector. Over 200 institutions, including banks, insurance companies, and fund administrators, work in UNEP in order to understand the impact of environmental and social considerations in a financial performance. The UNEP-FI's mission is the sustainable. The UNEP-FI's mission is to trigger a systematic change in the financial system to support a sustainable world. And this is highlighted in its motto: change the financial system, change financing. Change reflects a view of sustainable global economy that needs to be supported by sustainable financial system to promote the inclusion of sustainability issues in a traditional financial system and financial institution operations and decision in all markets, as well in its business in general and its governance. The National Social and Economic Development Bank in Brazil, the Bradesco, which is a Brazilian bank, also Banco Itaú, and some insurance company such as Porto Seguro, Seguradora Líder, Sul América, Terra Brasis, are some of the Brazilian financial institutions that associate to UNEP-FI. There are also a BNT ecological label, which is the associate to the Brazilian Association of Technical Standards. This is the ABNT, and it is an eco-labeling program. This eco-labeling program, which is a method of voluntary certification and labeling of environmental performance for products or service that has been practiced worldwide, being similar to an awarding, since the criteria are prepared in order to ensure the environmental excellence for promoting and improving products and process. As suggested by ABNT itself, it is an implementation mechanism for environmental policies directed to the consumers, supporting them in their choice of products that are least aggressive to the environment, and also a marketing instrument for organizations investing in this area. In comparison, toward green symbols or statements may be manufacturers or service suppliers, an environmental label is granted by a third-party entity in an unbiased way for certain products or services that are assessed based on various pre-established criteria. Hereinafter, we can note that if said rules are considered, we shall trail a path of corporate social liability that complies with an eco-development trilogy established by Ignacy Sachs, which means the development that economically feasible, socially fair, and ecologically cautious. But as we know, it's a very hard way to find. About the current legal overview of petroleum in Brazil. The controlling shareholder of Petrobras is the government of Brazil. So the Petrobras is a semi-public corporation headquartered in Rio de Janeiro. Despite its loss in 2014, approximately 21.5 billion reais, which is around $6 billion, the greatest loss since 1986. Mainly because of corruption and ongoing investigation, the company currently operates in 25 countries, and in 2015, it became the largest petroleum producer of the public companies in the world. After overcoming the North America ExxonMobil in the third quarter of 2014, and Brazilian ranked the 12th in biggest producing countries. In 2016, Petrobras reported reaching the goal of total oil production in Brazil, thanks also to the high average production of the pre-salt oil, which increased 33% in relation to the previous year. Brazil was a major contributor to a global oil surplus in 2016. Brazil's average monthly increase in production was the second largest in the world in 2016, just behind Iran, as shown by the U.S. Energy Information Administration, the EIA. The Petrobras was founded in 1963, and it no longer monopolized the petroleum industry in Brazil since 1997, in the light of Act 9478 of 1997, that distinguished the petroleum government monopoly in activities associated to exploration, production, refining, and transportation in Brazil, therefore allowing other companies, in addition to Petros to operate in the entire petroleum chain under consensus arrangement, provided that they are headquartered in Brazil. Prior to this act, other companies could not operate in the sales market of petroleum products in Brazil. It is an important to emphasize the Article 20, number 9 of the Federal Constitution sets forth that mineral resources are assets owned by the government, including the ones underground. And Article 177 of our Constitution defines the following as government monopoly: research and export extraction of fields of oil and natural gas and other liquid hydrocarbons, domestic or foreign petroleum refining, import and export products are basic derivatives resulting for those activities, and the sea transportation of crude oil originated in Brazil are of basic oil derivatives produced in Brazil, as well as the transportation through pipeline of crude oil and its products and natural gas for any source. Therefore, part of the jurisprudence here in Brazil understand that the Act 9478 is flawed by unconstitutionality, especially in declaring that the activities of exploration, development, and production of petroleum and natural gas shall be undertaken under concession agreements with private economy agents, Article 23, and the Brazilian National Agency of Petroleum, the ANP, is the administration. There are two major standpoints. One, that considers petroleum and natural gas as proprietary assets, that is, those not intended to a common or special purpose, constituting the equity of public law entities as object of personal right and riding rent of each of these entities, and that therefore represent the government available equity, not intending to represent the government as the owner of these assets. And other standpoint consider those assets to be a special purpose, that is intended to a specific purpose and therefore unavailable. Which the first standpoint mentioned denies the whose denies those assets as instrument as special purpose assets, and that shall directly serve to the domestic market, and therefore they shall be encouraged in order to make feasible the cultural and social and economic development, the well-being of the population and the technological autonomy of the country, as defined by the Article 219 of the Constitution. And in the same act, the purpose of the fourth of the Article 3 and 170 that respectively is the important to build a free and fair and solidary society, ensure the nation development, eradicate poverty and marginalization, and reduce social and regional difference, and the decent existence of everyone. The second standpoint, referring gas and petroleum as special purpose assets, does not consider that they shall be submitted to the free trade rules. Therefore, they should be monopolized by the government. It means that the subject act effective in Brazil, it's also unconstitutional and is visible, referring to Article 26, which sets the forth that the concession involves for the concessionary the obligation to explore and its account and risk it, and if successful, to produce petroleum or natural gas in certain part, granting in the ownership of those assets after destruction. Therefore, it's clear to transfer of the ownership of the oil and gas access to the private company, competition that, despite observed by the government and its obligation concerning the guarantee, leads to other factors for consideration of those assets exploration when promoting preference such as the search of for profit, deregulation, and softening of such economic sector considered strategy to the country by many of the specialized jurisprudence. Consequently, also indicates the petroleum transfer of to the private agents by the law 13,365 of November 2006. It's a very new law. It amended the law to 12,351 of 2010 that established Petrobras' minimum participation in the consortium for exploration for the pre-salt and the obligation for it to responsible for conducting and executing directly or indirectly all evaluation, development, production, and the eviction of the pre-salt exploration and production facilities. The pre-salt is the name given to any oil reserves area found under deep layer of salt lands. The pre-salt reserves found in the coast of Brazil are the deepest ones of petroleum found worldwide, and they represent the largest oil field found under the layers of the salt lands. Estimates suggest that the pre-salt findings may triple the oil and natural gas reserves in the country, and additionally, if the entire probable capacity of reserves is confirmed, Brazil may receive the condition of the largest producer and explorer of petroleum and its products in the world. Thus, prior to the change determined by the law 13,365 of November 2016, Petrobras, a company whose major shareholder is the Brazilian government, had exclusively in the pre-salt activities and obligatory participation with at least 30% of the investment in all consortia of the layer. In those consortia, Petrobras was an exclusive operator. In addition to having the Brazilian government charge royalties and the payment of signature bonus of the contract. As long as these requirements regarding Petrobras were met, both Brazilian and foreign companies could participate in the consortia. Now, with the change by the new law, there are no longer rules of mandatory participation of Petrobras. That is, consortia can be formed by entirely private companies regardless and whether they are Brazilian or foreign. The major argument raised in the project justification that gave rise to this law 13,365 concerns that recent crisis of corruption and other crimes that involves the company and that The major argument raised in the project justification that gave rise to this law 13,365 concerns that the recent increase of corruption, sorry, and other crimes that involves the company, and that because of this, it would no longer be able to efficiently meet the demands of pre-salt plan. Thus, in these terms, investigation of justice on Petrobras businesses since 2014, with consequent preventive detention of its managers, suppliers, and service providers, has been affecting the state-owned company, causing cancellations, delays, and disorganization of its activities. The series of scandals associated to the allegations of cartel bribery and money laundering caused an unsustainable situation to a company that has to implement one of the largest programs of investment in the world, amounting 220.6 billion US dollars in the period between 2014 and 2018. Additionally, associate or not to be claimed, Petrobras has been coping with financial pressures that jeopardize the fulfillment of its actions in the pre-salt fields. The scandals associated to the ongoing investigation may cause the state-owned company to face more difficulties to obtain funding from the foreign market, which may cause the non-fulfillment of its project's schedule. Furthermore, the international environmental is the profitability of pre-salt products may be considered. On the other hand, the contrary argument in this law is conditional on a specific situation of government. That is not a state policy, and it should have, since Petrobras may very well arise after the crisis. This already is happening and guide the resource of the pre-salt. Moreover, withdrawing the participation of this strategic state-owned company open space for the control of the oil in that region to the foreign companies. For example, mentioned by Walter De Vito from the advisory company Tendências in Brazil. In the case of the auction Libra oil field in 2013, the largest bid of the history of the country, the Chinese state-owned companies demonstrate the largest interest. They are willing to abdicate the initial profitability in line of the benefits of having strategic access of the oil reserves. Therefore, mainly concerning pre-salt, the foreign companies are not prevented to participate in the consortium process and may take strong advantage of the dividends and the open control of an asset owned by the government. It should be under public control in order to ensure the proper preservation of the means and ends associated in the line of public interests. So, in conclusion, as noted above, the Brazilian legislation is formed by several mechanisms of environmental protection based on the Federal Constitution of 1988. These legal instruments, however, only make sense if in accordance with a participative inclusion of the civil society and private economic agents. The administration of the renewable resource, therefore, is currently one of the agenda of most companies, regardless their size, in light of the social pressures for products and services that respect the environment and that may be included by the new globalized culture of sustainability. Brazil ratified international treaties for environment and natural resource protection, and it should actively participate in the international environmental law, which increasingly excels with proposals for regulation and protection of sustainability and cross-border nature. Finally, it's important to emphasize the petroleum subject, whose concessionaries plan is widely used in the country, mainly concerning the Brazilian public interest, which may be hampered by the recent withdrawal of Petrobras from the previously guaranteed obligatory equity participations. In this matter, I would like to thank all your attention in this talk, and I'm free to answer your questions. Спасибо.
Thank you very much for the wonderful lecture. If someone wants to ask a question, it's a good time for this.
Good afternoon, Professor Matsushita. I'm postgraduate student of Saratov State Law Academy. My name is Mikhail, and I have only one question. Thank you for your lecture. And I have a question. What kind of criminal or another liability is established for unlawful using natural resources in Brazil? Sorry, maybe I didn't understand well, but I have a question. Only one question.
No, don't worry. Thank you, Mikhail, for your question. For sure, we do have a strong regulation about criminal issues in order of environmental problems, but we do have a very difficult to apply this law because we are a largest country. It's very hard to find all those problems. Sure, the technology has now a big part of the control of these, for example, for the forests. But the criminals, they're very, very in advance of the law and of the law enforcement. So, for example, now this week, a newspaper in Brazil shows some satellite photos from the Amazon forest. So they cut the trees, take the wood, and put the top of the tree back in the floor. So if you took a picture from the satellite, you don't see the difference between those photos, but the tree, it's now on the floor. So and most part of those problems in environmental law takes place only the workers. The ownership of those companies, or not companies, or these groups of criminals, they are only supporting in economic way. Most of those workers has condition as equivalent of slaves. So unfortunately, we don't have big criminals against environmental issues in the jail for it. For example, now in the Petrobras, a lot of directors, management are involved in corruption, bribe problems. They contribute with the prosecutors. They pay some fees. They pay one director. Sorry, it's not a director. He's a management. It's the second level in administration of Petrobras. He pays a fee of $92 million about corruption involving regarding Petrobras. So now he's free, living in his house of 3,000 square meters, very comfy.
Thank you very much for your answer.
Thank you.
Someone else maybe have a question? Okay, I have a question a little bit. What do you think about an effective way of legal regulation of the activity of large car makers? For example, the scandal with Volkswagen Group, also known as Dieselgate. How can you comment this situation?
Yeah, well, actually, these standards are especially the Volkswagen scandal, which not takes place in Brazil. We don't have diesel cars for regular use in Brazil. Only SUVs for rural areas. But it's very hard to work in these issues. As you know about financing, about bank regulation, I think it's the same. The big companies, car companies, own largest part of the GDP in the world. The big problem is how we the population can not be used by these economic powers in the meanwhile we are living. So I really don't think we can have a very strong regulation about this pollution about cars. Sorry, I'm very pragmatical in this area. I don't think we can support it. Probably you as students, and I'm very proud to talk to association of students in Russia, because I also was a director of my association when I was in my PhD. And for sure, it's your goal to reinsure these kind of guarantees. Probably you must use less cars, and probably the cars can be better for us. And for sure, the most significant sanitization for this pollution matter is the US, which was the largest country providing pollution in the world. They don't want to sign any kind of treatment among ecological matter. Now his new president is very non-ecological president, so it was most unfortunately.
Thank you very much for the answer. So thanks again for your wonderful lecture. I believe that today we have begun a very good cooperation between Pontifical Catholic University of São Paulo and Saratov State Law Academy. And I hope to see you again. Thank you very much.
Yeah, thank you, Kirill, for the kind invitation. It's been a pleasure to talk to you, and I hope we can establish with Saratov State University very strong connection and use these new technologies. For me, it's very not common to use them. Besides, I'm not so old professor, but I'm also a very old school professional using these new technologies. But I think it's very good to be in touch with a very good group of students from Russia. It's a pleasure to be there with you, and I'm sure we can be in touch to do some other talks in the next times. Thank you again for your attention, and I hope you enjoy a very good weekend.
Thank you very much. Have a good weekend.
Thank you. Bye-bye. Thank you.
Have a good day. Thank you.
Thank you.
Все, всем спасибо за внимание, спасибо, что пришли. Всего вам доброго.